And so we're going to look at the financial and operational features of corporations. And again, as we've spoken about, is corporations are a production number. Even a small corporation has to have its own tax return, other than unless you've selected a subchapter S election with the Internal Revenue Service. You need to do some state paperwork. There's all sorts of things involved in the process. And of course, again, with the ease and the popularity of the LLC, which is going to be talked about in a little bit more detail in chapter 39, I want you to see, what are some of the techniques or pieces that you need to be aware of. So we're going to look at stocks, shareholders, directors, officers and directors, and some of the responsibility of officers and directors. And as I mentioned, it's not, the old cliche from the old Saturday Night Live show, the not ready for primetime players, is I do have an article criticizing the current situation, which legally protects directors of corporations, even if the corporation has been horribly managed and caused a lot of loss to the shareholders and others. And so I've written a law review article that is in submission right now. So since it's in submission, I'm not going to share it, but if it does get published in the next few months, I'll be sure to put that out somehow so people will be aware of it here at the Cameron School of Business. So I did want to mention that I did check this link, and this link does work. And this, of course, is kind of exhibit A for not directly for the reason of my article, but one of the concerns I have with these big public corporations is the directors seem to be the pigs at the trough, if you will. And the average directors at Facebook make over $400,000 a year, and which is pretty extraordinary. That's apparently 43% more than the average director of corporations. So it is really something. Now, what's happening here is something that has happened a great deal, and that is called a shareholder derivative suit. And unfortunately, shareholder derivative suits have gotten kind of a bad name because almost every public corporation that does a merger, an acquisition, so forth, gets sued by the shareholders of both corporations. One's saying, well, you acquired our company, you didn't pay enough. And the other one's saying, you idiots, you paid too much for that acquisition. And in fact, actually, a lot of mergers, a lot of acquisitions, the combined corporation is worth less than the direct combination of the two. So the shareholders of the acquiring corporation a lot of times are correct. Now, the way this game works is that the directors are supposed to sue the corporation on behalf of the shareholders. But that's unlikely to happen since the directors most likely signed off on the particular business move. So then once the shareholders have established that, then they can file a derivative suit. The reason they've been criticized is because there's an awful lot of them, even if there doesn't appear to be a particularly good reason to file them. And it looks like the lawyers, those dirty, nasty lawyers, are the ones who make out on the deal and not the shareholders, who are the ones who are supposed to be getting helped out in the deal. So it's just something to think about. And the question is if you're paying yourself through the nose from corporate funds, are you honoring your fiduciary duty as a director? So some things to think about. Looking at the term stock certificate reminds me, going back to a previous module where we talked about negotiable instruments, and we talked about the fact that many instruments are now being done electronically. The same thing with stock certificates. When I was setting up corporations in the 1980s and 1990s, when my full-time law practice was very active, we would order what's called a corporate book for the incorporator, and it would have a set of shiny, usually about 25 stock certificates. We usually set them up for 1,000 shares at $1 par. That was the minimum capital required to set up a corporation in Texas. And so they'd have 25 shares stock that would say par value $1 on them. And everybody was pretty happy with that. What has happened is, especially since the year 2000 and with the LLC being so popular, very few corporate books are being ordered today. I'm not setting up a lot of these. I'm not really doing much of this today because of the direction that my practice has taken. But in talking to attorneys who do set these up on a regular basis, most of them are not ordering corporate books today. It's just been phased out. And the stock that I own today, I just have certificates. I've got a statement from the University of St. Thomas 403B plan that says that I own shares in different mutual funds that the 403B is invested in. Same with some stocks that I bought through one of the online trading sites. And I've got to trust them that they know where they are. And occasionally I do get asked to sign a proxy for some shares of stock that I own. So it does indicate somebody's paying attention that I do own at least some of the stock that I do own. I get some paperwork on it, and it's often in the mail to sign as a proxy. Now, the proxy is usually to vote for the board of directors. Now, here's the problem. I don't know those people. And they give you a little bio on them if you care to look it up, or they give you a link to look up their bio. But the bios do tend to be awfully similar, and they don't tend to be particularly exciting. But, if you only own a handful of shares of stock, you're not going to have an impact on that corporation, regardless if you vote against the whole slate or you vote for the whole slate. So it's a kind of a fruitless exercise. Most of you are familiar. I know we have a number of accounting graduate students on the call tonight. Most of you are familiar with bonds. Bonds are essentially a debt instrument, but instead of borrowing money from the bank, a bond is issued to borrow money from others in the community, sometimes banks, sometimes wealthy individuals, and so forth. And what happens is that they're generally issued at a particular interest rate. Investing in bonds often involves whether the bond is a good deal at the time. So if the bond is paying a high interest rate, the bond may trade at a higher value in the secondary market. If the bond is paying a very low interest rate, below the current interest rate, then the bond may trade at less than its face value. And that's how this is done. Bondholders are not involved in operating the business. They do not participate. They do not vote. Now, this is, let me see what I want you to do here. Those are pretty simple definitions. This is a series of several slides here, folks, that I think you might want to, as I've said many times in this course so far, is your super slide set. We're going to be looking at several consecutive slides here that might be, if you're concerned. Many of you, again, already know these terms, and they're just so minimal or so basic that you don't really care to keep track of them. And that's fine with me. But if you are not familiar with this, then you may want to add these slides to your super slides to make sure you repeat and learn the terminology. Common stock is what most corporations set up, and it's your basic stock. And it's what we usually think of when somebody says stock. Preferred stock is a hybrid between a bond and a stock. Preferred very well means this, that they get their dividends that are promised, the specified dividend, before the common shares of stock can get any dividends. So that's what preferred stock means. Now, cumulative preferred stock means if the corporation doesn't have the money to pay your preferred stock dividend in year one, if they do have it in year two, they again need to pay any back due dividends before they can pay any dividends to their common stockholders. Another slide you may want to add to your super slide set is slide 6 of chapter 38, common and preferred stock. So the alternative to cumulative stock is non-cumulative stock, which means if you're preferred stockholder, corporation doesn't make any money in the current year, You may not get your full dividend, or you may get partial dividend or no dividend, and they don't have to make it up the following year. Now, a rare form of preferred stock is participating preferred stock, where you can get a little extra after your guaranteed dividend once the common stock gets their piece. I have not seen that very often. Non-participating is the more common form of preferred stock. Now, before we move past this, there's a term that is not in here that I think should be, and it is the term convertible preferred stock. And what happens is a preferred stock is, like I said, more like a kind of hybrid between a bond and a stock certificate, but you do not participate in the increase in value in the corporation. So convertible preferred stock is kind of the best of both worlds. When the stock is still fairly young, not worth a whole lot, excuse me, you get that preferred dividend. And then if the stock value takes off, you say, aha, I've really got it in the bag now. I'm going to switch my preferred stock and convert it to regular stock because the stock has increased in value. So convertible preferred stock is a very nice tool. For some reason, it's not in this set of slides. So let's look at another slide. Again, if you're not familiar with these terms, you may want to add these terms to your super slide set, and that is stock warrants. And stock warrants are pretty interesting and often are used for a startup company. So they'll come to you and they'll say, this is a real situation. I actually had this happen to me, is they came to me and they said, hey, we'd like to sell you, you have to buy at least $5,000 worth of stock, but we'll sell you $5,000 worth of stock at $5 a share. And we're also going to give you a set of warrants to buy more stock at $5 a share. Now, what's happening there is they're saying what you're doing is you're betting that the stock will increase in value. And therefore, when you exercise that warrant at $5, say the stock is at $7 or $8, well, then you've got a built-in gain right away. Now, in the particular situation I'm thinking of, which was a penny stock I had invested in, is I had lost a lot of money on the stock already. So when they called me offering to let me spend more money on this stupid stock in exchange to stock warrants, I said, nah, I don't think so. And that was a very good call because that stock is trading at about $3. So I would have lost all of the money that I spent on the stock, or most of it, and the warrants would have been worth virtually nothing. So anyway, something to look out for, but it's often used when you're trying to get a stock rolling. Par value, I mentioned a moment ago here in Texas, we would do 1,000 shares of stock at $1 par. But you must have that $1,000 in the bank. Now, if you increase the number of shares and the number of shares at par, then you need to put more money into the capital stock of the company. So what happens is a lot of companies, especially if they're moving to larger numbers of shares in order to go onto the exchanges, will switch over to no par stock. Or if you incorporate knowing that you're going to go on the exchanges is to go to no par, then you're not tied to having a certain amount of cash in the corporate kitty. A term that I hear a lot more recently than I used to in the past. It's not a positive situation, and this is where you've got the par value stock. It's put out there, and the corporation does not have the cash in the bank, which means the stock appears to have more value than it actually does in the corporate treasury, watered stock. So keep that term in mind. This is slide 8 of chapter 38. Now, treasury stock is stock that is returned to the corporation by gift or purchase. Gift might be one of the founders of the corporation wants to strengthen the capital base of the corporation. Purchase, a lot of times, if corporations have a lot of cash and they think their stock is a little cheap relative to the market, they will go in and buy their own stock, making it treasury stock, in order to get the price of the stock higher. Now, this ties in. This is why I'm not thrilled with the way Module 8 is organized by this particular author. I like the whole book, but just pointing out the fact that I would have put promoters in this thing. Remember, we talked about promoters already in Module 8, stock subscriptions. And this is when a corporation is being put together, you sign an agreement to purchase stock. If they get enough people who are willing to do that, then they can get the corporation started. And it is usually a binding contract to buy stock when the stock is offered to you at on particular terms. Now, in general, unless a stock is marked as restricted stock, you can sell it to anybody you want if you can find anybody who wants to buy it. And of course, with penny stocks, unknown stocks, you may not be able to find somebody who wants to buy the stock from you. You may be stuck with it. But in many startup ventures, they will put a 1 or 2 year hold on it. So when you buy into the stock, you get a stock certificate or you get a contract that says you are restricted from selling the stock for 2 years. What's happening there? What they don't want to have happen is they're out there busting their butt to get the stock sold, get a lot of people enthused about the company, and they don't want you to buy the stock. They're out there working their butts off and they get the stock price up, say $5 a share more than you paid. And then you say, hot dog, I've got a quick gain here, and you sell all your stock. And in a stock that is not heavily traded, a sale like that can torpedo the price of the stock, defeat the purpose of the corporation. So it's not unusual, again, with startup companies to restrict the transfer of the stock in the early going, but usually past that, it's not too much, unless it is designated as a closely held corporation, in which case the stock is restricted perpetually. So on a transfer, what have you got? If you've got physical certificates, then you're going to sign the certificate and turn them over probably to your stockbroker or to your trading company. In a large corporation, generally there are trading agents. They're going to identify your electronic shares because, again, much of us is done electronically today. And then they keep track of everything to make sure that these are legitimate transactions. And by the way, Article 8 of the Uniform Commercial Code, Article 8 of the UCC, deals with investment securities. So what do you have as a shareholder? This is one of my favorite lines, this first bullet up here. And some of you may know when I was first out of law school many years ago, I went to work directly for Shell Oil downtown at One Shell here in Houston. And I just picture somebody walking into the lobby of the One Shell building and saying, hey, I'm a shareholder. I want to inspect the books and papers of the corporation. And I can predict that that person will be hauled away by the security guards and will not be seeing anything. So what do you have a right to do? Well, basically, the big public corporation, they're going to be issuing quarterly reports and annual reports, and you have a right to see those. Now, you can go to a shareholders meeting, and if you think that they're not telling you the whole story, you can certainly ask as an issue at a shareholders annual meeting, which you have, again, have a right to attend as a shareholder, to check things out. Now, of course, sometimes people who are environmental activists, and as we know, oil industry is heavily involved in this current election cycle, what people who are environmental activists will buy one share of stock so they can go to the Shell Oil annual meeting. Well, what happens if these people start getting up and jumping up and down and creating a furor, then they're going to be hauled out by the security guards. They're not going to get to present. I want to talk for a minute about something that's important. And folks, we're pretty far into the course. We're in module 8 of 10. So I can't remember if I've told this story earlier in the semester, but preemptive rights are the rights of existing stockholders to buy newly issued stock in order to keep their percentage interest in the company. And this is very important in startup companies. So I have some executives who've been asked to leave big corporations and to run some well-financed startups. And part of the deal is they're going to get a certain piece of the company. But one of the things that we try and build into those executive compensation agreements is that they're being offered a percentage of the stock, period. So it's not 100,000 shares, it's a 4% interest or a 5% interest to make sure no matter how many shares are issued, that the number of shares that they get stay consistent. And then, of course, if you're a shareholder, again, you could bring a shareholder derivative suit, which we talked about on the Facebook slide. And if there is a dividend declared, now remember that not all corporations award dividends. The situation with many of the high-tech companies like the Apple computers of the world just say, we're set up as a non-dividend paying stock. You're going to get your return because we're running the business well and the stock will become more valuable. Well, some people feel that because Apple in particular has so much cash on hand that if they don't start buying stuff and making their company more valuable with the cash, that it's time for them to start paying a dividend. So it'll be interesting to see what happens with that. Now, the board of directors is required, at least in Texas and most states, to have at least one meeting per year. You're going to need to give whatever the bylaws call for a notice. To have a meeting where something happens, you need a quorum. And of course, you need to announce the purpose of the meeting. Now, shareholders have a right to vote for the directors. The directors then run the corporation on their behalf. Also, if there's certain policy issues, like, for instance, asking to approve a change in the CPA firm that does their annual audit, asking for approval to formalize an acquisition or a divestiture, and a change in the bylaws, for instance. So what do you get for your common stock? In many cases, you get to vote it. But I want to be clear on this. I didn't mention this earlier in this chapter, but Yahoo Corporation, when they went public, they expanded number of shares. They did something interesting. If you are a Yahoo stockholder, you did not get the right to vote with your class of publicly issued stock. So the two guys that started Yahoo have the voting stock. They don't own a majority of the stock anymore, but they own all of the voting stock. That is a very unusual situation, and it's one, frankly, from my standpoint, I would not purchase shares in Yahoo because of that shenanigans. But in any event, normally when you are a shareholder of common stock, you do have a right to vote for one share of stock. It equals one vote. And if there's, say, 10 directors, then you have 10 votes. Now, in straight voting, you can cast 10 votes. You don't have to cast them for the 10 that the board of directors has recommended, but you have 10 votes. Now, in cumulative voting, you could cast all of your votes or whatever's the limit for particular directors, and that may help you. And this is how people like the Warren Buffett and Brady Hathaway Corporation get control of corporations, where they buy a big chunk of stock that has cumulative voting, and then they vote all of their stock for the people that they want, the one or two people they want on the board. And as I mentioned a few minutes ago, preemptive rights are a big deal, especially in startup businesses. And this is exactly the definition right here at the top of this slide, and keeps proportionate control. And there are a lot of different ways that this can happen. Now, if some of you are familiar with the movie The Social Network, which was about the founding of Facebook, referring to Facebook again, one of the scenes in there is that this young man who was an accountant at Harvard, accounting student at Harvard, who was the accounting person for Facebook startup, thought he owned a certain percentage of the company. Then in the middle of the night, Zuckerberg quits college, moves to California, gets a whole new funding source, and substantially increases the number of shares of stock. But of course, he didn't share back with him and some other people who had been early supporters, investors of the corporation. And so part of the case, the social network, is a lawsuit against Zuckerberg and his new buddies to say you did not honor your commitments to your earlier stockholders. Benihana is a case. I think we actually cite Benihana in my current law review article I mentioned a few minutes ago. And the issuance of preferred stock with preemptive rights, is that true or not? Well, it's interpretation of the judge, and that's the way these things go. As I mentioned, derivative suits are kind of the pain of the big corporations, big public corporations, I should be clear. And so usually what they're arguing is the corporation has done something it's not supposed to do, and that's ultra vires, to operate outside of its corporate allowance. Purpose of a derivative action is twofold. Equivalent of suit by shareholders to compel the corporation to sue, a suit by the corporation against those liable to it. Now, this is a special provision in Delaware, and again, this is in my current pending article, that what you need to do in Delaware is you need to go say, mother may I, to the board of directors. You need to say, look, you guys have not pursued something or not pursued someone, and we want you to do that. And if the board of directors refuses, then the shareholders have a right to file the lawsuit themselves as a derivative action, derivative from the board. But that doesn't mean that it's going to be a successful case or a particularly legitimate case. Now, one of the biggest shakeups as a result of the 2008-2009 meltdown, of course, the subprime mortgage market took a huge toll on AIG and Citigroup, among other major corporations. Merrill Lynch took a big hit, as many of you know, and ended up being owned by Bank of America and so forth. So the derivative suit stemming from losses suffered as a result of subprime mortgage, and the court dismissed the shareholder derivative lawsuit. And part of the argument is that could anybody have predicted that the stock market was going to crash and the real estate market were going to crash as much as they do? I'm, again, probably more on the plaintiff side of this case, just so you know, not because I'm a plaintiff attorney, because I'm not, but because I think the directors needed to be more engaged and more careful about what they did. Dividends are a very popular subject, and there are some corporations, a lot of times we refer to blue chip stocks. A lot of blue chip stocks, by habit, by design, pay dividends. The best known example of that are used to be the railroads. I don't know if they are anymore, but utilities. And I actually do have a utility stock, and it does pay a nice dividend. I've got it set up on what's called dividend reinvestment, which means if I get $200 in dividends, that's used to buy 2.5 shares of stock at its current price of around $80. And so that's how that works. And now it's considered regular income to me. So even though I ended up with more shares of stock and not cash, I still have to pay cash to the IRS. I can't give them an IOU. Now, one of the most famous cases on dividends, and this is referenced at the beginning of my current article on boards of directors, is the Dodge case. And it's actually the Dodge brothers. And Dodge brothers were suppliers to Henry Ford. Henry Ford was largely running an assembly plant when he was making Model Ts. He was not making all of the different components or subcomponents of the automobile. These were being made by other companies, especially the Dodge brothers' big production machine shop. So in times when Ford couldn't pay for the parts, he would issue stock to the Dodge brothers. So that worked for a while, but then the Dodge brothers said, hey, you know what? We're not getting any dividends on the stock, so it's not such a good deal for us. And so they went to court in Michigan and sued Ford and said, you're making money, and instead of paying dividends to us, the stockholder, you're reinvesting in your plant, which is okay, but that reinvestment is using my money or the Dodge brothers' money. So the Michigan court actually ruled against Henry Ford. Well, how did Henry Ford deal with that? Well, what Henry Ford did was he bought out he was doing well by then, bought out all of his investors, including the Dodge brothers. Now, here's a couple interesting pieces. The Dodge brothers set up Dodge Motor Company, which later became Chrysler Motor Company and had the marks Dodge, DeSoto, Plymouth, Chrysler. Later, as Dodge unfortunately did not do well in the 90s, it kind of closed down. The Plymouth division was closed. DeSoto had been closed much earlier than that. And what happened is that Chrysler Motors has been through some very hard times, is now owned by the Italian company Fiat. And so they also, along the way, had acquired American Motors, which had by that time also acquired Jeep. So Jeep and American Motors basically were folded into, the remnants of it were folded into the Chrysler Dodge company that remained, that is now part of Fiat Chrysler Dodge. So kind of an interesting history there. Fiduciary aspects, not between the shareholders in the corporation, but it may be possible in a closely held corporation. Again, another solid slide. This is slide 22 in chapter 38. The directors have the power to conduct the ordinary business of the entity. They have a duty to establish general policies and elect higher officers to execute the policy. Bylaws provide the method for calling director meetings and for time and place. The bylaws stipulate payment of directors' fees. If not mentioned in the bylaws, service is uncompensated. Now, I want to point out that I am, in the past, I've served as directors of several charitable or nonprofit corporations. Those were clearly not paid. I am a new member, effective this month, of the board of directors of the Greater Heights Chamber of Commerce, and that is an unpaid position by a nonprofit organization. And usually you do that, as I do it, to give something back to the Greater Houston business community. Now, directors and officers may have personal liability both in tort and contract. However, it is very uncommon. First of all, one of the things that I'm always very careful to advise all of you business law students is, if you are asked to serve as a director, whether it's a for-profit or a nonprofit, always check to see if they have director and officer insurance, D&O insurance, so that if something bad happens, you are not personally exposed. You've got an insurance company in there to protect you. That's number one. Number two, most business judgment decisions by boards of directors are protected. And that rule, again, goes back to the Dodge brothers. And directors are better equipped than the courts to make business judgments. The courts generally rubber stamp what the board of directors votes for. Now, there is a duty of loyalty, and you need to be careful about this, because what I have seen are situations where people are playing both sides of the fence. If they see an opportunity, they go out and do it as individuals, cheating the business that they work for of that opportunity. And that is a violation of duty of loyalty and is illegal. This slide, another good slide, slide 24, the liability officers and directors. They have the liability of due care. They have a duty of good faith. And again, you want to make sure that they're indemnified by the structure of the bylaws of the corporation, but that they also purchase liability insurance to protect directors and officers. Again, that's the D&O insurance I mentioned a moment ago. And then a lot of this is spelled out in the Model Business Corporation Act.